All right, are you Mr. Hoffman?
Yes.
All right, let's call People v. Sean Hoffman. It's file 25-93368FH. Counsel, you want to state your appearances, please?
Jeremiah Buffalo Ward on behalf of the people.
Your Honor, Mike Vogler representing Sean Hoffman.
All right, and this is a docket call, but also the defense has filed a motion to quash count 2, the R&O. I reviewed the transcript, the motion, the authority cited, and just this morning, the memo filed by the people. Mr. Vogler, go ahead with any argument.
Your Honor, not much to add to what I've already written to the court, but it seems to me that there are 3 cases, all unpublished, that were provided to the court, all of them identical in terms of this case, with the exception of the resisting and obstructing charge here versus the ones in those 3 cases. In those 3 cases, all 3 resisting and obstructing charges convictions were upheld, along with the convictions for fleeing and elude. And I submit the reason they were upheld, and I think the court in each and every one of those cases cited the fact that after the fleeing and eluding offense was completed, the defendant in some way or another disobeyed a direct verbal command from the officer to do something, either stop, get out of your car, or what have you. In this case, once that fleeing, eluding episode was done, in this case, as alleged, the defendant got out of the car, got into the house, came back out of the house. There was no verbal command in between from the time he left the car, or even when he was in the car and got out and got in the house and came back, that he disobeyed.
So the prosecutor's argument seems to be both below and here that the light signal itself was a command of some kind, was a lawful command. And then by fleeing on foot, there's a failure to obey that lawful command. Is that right or wrong, or what and why?
I think it's wrong. I think that the command, the 3 cases I provided to the court indicated a verbal command was what was necessary. And to say it's otherwise would make every fleeing and elude would be in a resisting and obstructing. I don't think that was the intent. The courts, from what I can tell, don't believe that that was the intent, that the disobeying, the obstruction part of it, the disobeying has to be to a verbal command, a lawful verbal command.
All right, thank you. Mr. Burko, are you arguing this time?
I am, Your Honor.
Go ahead.
Your Honor, defense's reading of the statute here would require that there needs to be a verbal command in every single R&O. That would prevent people who can't hear from being convicted of R&O, and it would prevent a lot of situations for R&O. But it's not just R&O, Your Honor. I mean, even in the title, it says assaulting, battering, resisting, obstructing, opposing. Within the statute, it even says endangering. Now, there is a part of the statute, and I believe it's sub 7 A, where it says that obstruct includes. The word includes was chosen very specifically, Your Honor, meaning, yes, it can be that. It doesn't say includes failure to obey a lawful command and excludes everything else. It just says that it includes. Your Honor, I do think that we can have our cake and eat it here too. I think inherent in almost every single fleeing and eluding there is an R&O. That aside, Your Honor, the moment Mr. Hoffman decided to haul from that car, that was a new crime. And I do believe that the element of knowing that he's being chased, he admitted, I'm afraid of the cops. And I don't think that it requires a verbal command. I think that the flashing lights, knowing he was being pulled over, is adequate enough to know that he was hindering, that he was resisting, and even if we're not going to say he was obstructing, he certainly did endanger those officers that day. And finally, Your Honor, if we were to interpret defense's reading of this statute, it's an invitation to run. The moment I get pulled over to the side of the road, it is time to beat the pavement, because if I can't hear that cop tell me to stop, then there's no extra crime. Thank you.
Any rebuttal argument, Mr. Booth?
No, Your Honor, I'll stand on what I've already said.
All right, on a motion to quash, typically that's viewed for an abuse of discretion. However, a court abuses its discretion when a decision makes an error of law. So determining the scope of a criminal statute is a matter of statutory interpretation, which is a question of law. Therefore, my review of these questions would be de novo, requiring no deference to the district court. In this case, I'm going to grant the motion to quash count 2, resisting and obstructing. Here, there's a very specific statute about fleeing and eluding from the police. It's not an invitation to run all the time. It's a felony. So people don't stop their car when they're in. The statute shows that the legislature knows how to write such a statute, that if they fail to bring the vehicle to a stop when they're given a signal by all sorts of very specifically described methods, then that's the crime of fleeing and eluding. You know, I recall in the past, there were a series of cases trying to sort out, you know, is running from the police on foot an R&O? And is it an R&O at all? And the cases were decided that yes, running from the police on foot can constitute an R&O, resisting or obstructing police, when it is failing to comply with a lawful command. And here, the visible signal to stop the vehicle is not the same as a lawful command. Command does imply some verbal command that is given. And you know, all it takes is then if an officer says, hey, stop, and then they keep running, well, that's resisting and obstructing a lawful command, and whether they heard it or not would be a fact question for a jury in certain situations. But here, there were no facts that really called into question. There was no command given to stop once he's outside the vehicle. Therefore, I think there's a necessary element that would be missing. So the defense motion to quash count 2 is granted. And Mr. Vogler is the prevailing party. Can you submit an order to that?
I will, Your Honor.
So for purposes of docket call, then, where are we at here?
Well, unfortunately, the communication with my client is very troubling, at least from my perspective. The last time, I think we were in court, Mr. Hoffman, I thought, indicated that he wanted to go to trial. I think that's still what he wants to do. I don't know for 100%, but he has a way of being able to communicate with me. He can pick up the phone in the jail and tell them, leave a message. I will certainly come over as fast as I can to see him.
Okay. All right. So, Mr. Hoffman, your lawyer's telling me, are you awake there with us?
Yeah.
Okay. Your lawyer's telling me that you don't seem super interested in communicating with him about the case, but that he thinks that you'd like it set for trial. Do you want me to set this for a jury trial for you, Mr. Hoffman?
Yes.
Okay.
If you have an ordinary to flee and elude, you have to be pulled over. And I was never pulled over. It's even states it in the police report that I was in the house for 22 seconds. If I was in the house for 22 seconds, that means that there was no pull over.
Okay, well, you can sort that out in front of a jury then.
So, bye.
All right, well, I guess he's left the meeting. I guess confirming Mr. Vogler's statements that he doesn't seem too interested in communicating with folks about it. He has, I guess, indicated on the record as well as to you then his desire for it to be set for a trial. Well, that puts you in some amount of difficulty, Mr. Vogler, if he's not communicating with you about the strategy for that trial. I think at this point, especially since he's in custody, we should just give him a date. I could set this for Thursday, Friday, January. Would you need 2 days or would this be 1 day?
I think it's a 1 day.
1 day.
We give you a trial Thursday, January 22nd. Allow witness and exhibit list to be exchanged within the next 21 days. Yes, if Mr. Hoffman does have a change of heart, I want to allow and communicate with you. I'll set it one more time on the December 1st docket call.
Thank you, Your Honor.
At 9:40.
Your Honor, there won't be any other offers. We're going straight to trial, so I don't know if unless the defense has a need for a docket call.
Well, I think I want to set one since he's not communicating with his attorney and left this hearing as well. I guess I do want to have another hearing, at least where we can assess his participation in this for a moment. So that'll be December 1st at 9:40 a.m. Anything further from the people? Anything
Your
from the defense? Okay.